Share the screen. Screen is blank. See something, guys. Okay. I remember, good evening, members. I remember last week we were still tackling the sale of goods, and I wanted to finish it today. I don't remember where we stopped. I really don't remember where it stopped. I believe we had finished this, transfer the property. Okay, let's begin with the rules relating to the transfer of property. Rules, legal rules relating to the transfer of property. We're looking at property in unascertained goods. They say under section 18, no property can pass unless and until the goods are ascertained. Now, when they say an unascertained goods, it means these are the type of goods that you're not sure of. For example, there are goods that probably you bought, but they are supposed to be manufactured at a future time. You go to roofings and you want iron sheets, and they tell you we shall prepare these iron sheets in October, but you paid your money. Now, those goods that are manufacturing are unascertained goods. So they're telling you the property in those goods only passes when the goods are ascertained. The moment they are manufactured and have been sent to you. Now, property in unascertained goods. Under section 19, where the contract is for ascertained or specific goods, the property is transferred at such time as the parties intend the property to be transferred. Section 19 sheds some light on this by providing that for ascertaining the intention of the parties, regard shall be had to the terms of the contract, the conduct of the parties, and the circumstances of the case. So ascertained goods are goods that are already there. You can see them, you can touch them. It means they are really ascertained. Just like you go to the shop and you say, I want that shirt, because it is already ascertained. In the event contrary to the intention, in the event a contrary intention does not appear, section 20 provides the rules for ascertaining the intention of the parties. Where the contract is unconditional and the goods are specific goods, property passes when the contract is made. So the moment you go to roofings and you pay for your goods, genuinely you find the iron sheets ready and you pay for them, then they bring the iron sheets to your place. Now automatically, that is, the contract means it was unconditional. And at that time, the property in the goods has passed. Where the contract of the sale of specific goods and the seller is bound to do something too, the goods for the purpose of putting them into a deliverable state, property does not pass until that is done, and the buyer has notice thereof. So they're telling you, if there are specific goods and delivery, it's the seller supposed to deliver them, please. Until he has done that, property will not pass. It only passes when he has delivered the goods to you. While the goods are in a deliverable state, but the seller is bound to weigh, measure, test, or do such other things as may be necessary to ascertain the price. The property does not pass until such things are done and the buyer has notice thereof. So those are some of the things you must know. When the goods are delivered on approval or on sale or return, does not pass until, excuse me, let me just first pick this code. Yes. All right. When the goods are in a deliverable state, but the seller is bound to weigh, measure, test, or do such other things as may be necessary to ascertain the price. The property does not pass until such thing is done, and the buyer has notice thereof. For example, you go to buy machinery, but when they bring the machinery, they have to first test, measure, and establish the price. That is what they are trying to mean. So the person has to establish, the buyer has to establish, the seller is bound to weigh, measure, test, and show that genuinely whatever he's doing, it is of that weight, it is genuinely the machinery. So you ascertain the price. When goods are delivered on approval or on a sale or return, property passes when he signifies his acceptance to the seller or does anything consistent with adopting the transaction. So when they send the goods to you and you receive the goods and you sign that you received the goods, the property has passed. Then two, where the buyer fails to signify his approval or acceptance to the seller, but retains the goods without giving notice of rejection, then if a time has been fixed, the return of the goods, or if no time has been fixed, on the expiry of the reasonable time. They might give you goods, and you look at the goods, and you're not comfortable with the goods, but the seller walks away, and you retain the goods. Or you have a right to inspect the goods, but you cannot inspect the goods there and then the seller walks away. So you retain the goods. If you refuse the goods, if the timer has been fixed, then you send the goods within that limited time. But if the time has not been fixed, then you're supposed to return the goods within a reasonable time. Reasonable does not mean I give you things and you begin bringing them back in 1 year's time. That is not reasonable time. But if it is only a few days, that is reasonable time. And expect that something of that kind in your exams. The examiner likes such things. Where there is a contract for sale of unascertained or future goods by description and goods of that description is in a deliverable state are unconditionally appropriated to the contract, property passes upon appropriation, and where the seller delivers or to a carrier to deliver the goods and does not reserve the right to dispose the goods, then the goods are appropriated. So, for example, you give a carrier, a truck driver, goods to take, bags of rice to take to Mbarara. But you reserve the right to sell yourself. That means the property and the goods has not moved. But the moment you give him the right to sell the goods, if at all he gets into an accident and he feels the goods will get spoiled, he has the right to sell them. Then at that level, you've given him, let me say, 10 bags of, 10 sacks of, 10 bunches of matoke. He gets an accident and realizes the matoke might ripen and get spoiled. So he has the right to sell. At that level, by the time he begins selling them, that is the time the property in the goods would have moved. Reservation of title. In some cases, a seller can reserve title of goods. Section 21 allows a seller, by terms of the contract, to reserve his right of disposal until certain conditions are met. In this case, the property in the goods does not pass until such conditions are met. So you look at the Ramafla clauses after a famous case of Aluminium Industries versus Ramafla Aluminium Limited, in which case the plaintiff supplied aluminium while reserving title of the goods until full payment had been made. The defendant went into receivership. The English Court of Appeal allowed the plaintiff's claim for the value of unprocessed aluminium. So they're trying to tell you that, remember when somebody got into liquidation or receivership means you've gone bankrupt. So at that level, you do not have contractual capacity. But remember, the sale of goods rises out of contract. So the moment you become bankrupt, but somebody sent you goods, but he reserved that clause. He said, please, you paid these goods, you paid for these goods, but you've made a partial payment. Until you finish the payment, that is when the goods will pass to you. Please, the moment you become bankrupt, he has the right to come and pick his goods. Just like if you sell a car, that will be the same thing. So they're telling you in Kenya, the Romofa case was upheld in Hochest East African Limited versus Kisumu Cotton Mills. In this case, the plaintiff supplied stock items to the defendant with a reservation of title clause included in the sales invoice as one of the conditions of sale. The defendant went into receivership, and the value of the unpaid goods was 5,000 Kenyan shillings, and the total indebtedness exceeded 2 million Kenyan shillings. The court held this clause effective. The receiver could not sell the goods to recover money owed to the creditors. The property in the goods effectively remained with the seller. So, some of you who get into business, let me say guys who sell cars, this is a very good one. Put a Ramafra clause in most of your things, unless the person has paid each and everything. But the moment there is always someone that you still have to pay, title does not move. The other party has a right to come and pick the item and sell it. Okay, risk and the property in the goods. Risk under section 22. Under section 22, risk passes prima facie with the property, even if the goods have not been delivered. If the parties intend for the risk to pass at any other time, then the contract must expressly provide for this. In the absence of the express provision, then the conduct of the parties may be relevant in evidencing such intentions. Now, when they say that risk prima facie passes with property, it means for you to prove that title in the property in the goods has passed, look at the risk. Ask yourself, who will have this risk? The same example I gave you the other time, that if you bought eggs from Chikubu and they bring them to your shop in Bukoto, and somehow they break around one area, please, the person who was delivering them is the person having the risk. But if they bring them to your shop and they get broken there, the risk is yours. So they're telling you under section 21, risk remains with the seller in cases where there is a reservation of title clause. So transfer of title. Closely related to the transfer of property is the transfer of title. Title simply means the right of the property in the goods. So when they tell you transfer of title, It means that you become the rightful owner of the item or the goods. That is what they mean, the title. Title means you're the rightful owner of the goods. If you go to a shop and you buy a shirt and they give it to you and they give you the receipt, you're the rightful owner of the shirt. The moment you wear the shirt or you give it to another person and the person wears it and is on the street, the shopkeeper cannot say, please, that is my shirt. Because he gave the title to you. The common law rule that governs the transfer of title is the Nemo Dat Code non-habet rule, meaning one cannot give what he does not possess. So this general rule is set out in section 23 of the Act in the following terms. Subject to the provisions of this Act, where goods are sold by a person who is not the owner thereof, and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title than the seller had, unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. Now, this is a very interesting one. Be very cautious. Let the examiner not confuse you. That so-and-so stole this thing, he just stole. So that means he does not have title. And he also sold the stolen item. So the person who has bought the stolen item does not have the title in the goods. That is the principle of Nemo Dat. The problem then arises with this distinction of title and property. Is this, suppose a party to a contract of sale enters into a contract and purports to transfer the property in the goods when in fact he does not have a good title. How does the law distribute the risk and property? Now that is we call it an intellectual position. You ask yourself, at this level, do you expect when does the risk in the property move? Because it is stolen property. So the moment it breaks, what happens? Who do you sue? That is why they're trying to ask. So they're asking you that now putting the rules, legal rules relating to the principle of Nemo Dat sale. The general rule is that set out in section 23, but this section incorporates the equitable doctrine of estoppel, where the owner of the goods has, by his conduct, misled a third party into purchasing the goods. He will be estopped from denying that the actual seller was the true owner of the goods. Estoppel means you make a statement and the other party relies on that statement and enters into contract. So you're stopped from denying whatever you said earlier. That is what they call estoppel. In Eastern Distributors Limited versus Go Drink, a party X who owned a van wanted to buy a car from Y, but did not have money to pay the deposit. X and Y agreed that X should submit proposal forms to the plaintiff finance company within X. Within X was to apply to acquire both vehicles on hire purchase terms. This joint misrepresentation was aimed at ensuring X obtained money to pay and paid the down payment for the car. The finance company accepted the proposal for the van, but rejected that for the car. In a subsequent action, court held that X was stopped from denying that Y was the owner of the van. Yes, you can't deny. However, the law recognizes instances of circumstances in which a buyer can acquire a good title of goods sold by a seller who had no good title, as contemplated by one of the general rules of sale, i.e., the transfer of property. Now, this is one other thing that I wanted to let you know. I didn't want to bring it the other first time, but you have to know that there is transfer of property even if you do not have property. If the other party did not have notice of what you did, and this is what happens to people you claim are land grabbers. There is a principle of, in land law, remember land is not a good, but there is a principle in land law that runs away from the principle of neighborhood. It says that he who has bought land without notice, without prior notice of all the thuggery of the seller, buys land and acquires good title. So when you realize what these guys always do, when they dupe somebody, they will change his land. Today, he sells it tomorrow. And after a while, another person buys it. The moment it reaches a third party, a third person, please, the owner cannot pick it from the third person. It is already gone too late. So they're telling you sell under avoidable title. Section 24 provides that where the buyer has a voidable title, but the title has not been avoided at any time of sale, the buyer acquires a good title provided he buys them in good faith and without notice of the seller's defective title. That is one thing that we're discussing. So sell by a mercantile agent. Under the Factories Act, mercantile agents who are not owners of the goods can, in certain circumstances, sell and confer a good title to the goods. Under Section 1 of the Factories Act, a person who is in the customary course of his business as such agent has authority either to sell or to consign goods for the purpose of sale, or to buy goods, or to raise money on the security of the goods. This definition is also the same in Section 26 of the Sale of Goods Act. Example, Fox versus King, where Fox owned a car and delivered it to a mercantile agent for sale at not less than £575. The agent sold the car to King for £340. King bought it in good faith. Fox sued King to recover the car. Court held that for purposes of the sale, King had acquired a good title. The purpose of the law is to protect third parties, since in such sales, an impression is created that an agent owns the subject matter of sale. So these are exceptional provisions. I want you to know that the general provision is he who has no title in the goods cannot pass on good title. That is the general provision. But here we're discussing exceptions. We sell by a seller still in possession. Where a seller sells goods, in other words, passes property in the goods, but still retains the goods and sells and delivers the goods to a third party for value who has no notice of the previous sale. This third party acquires good title. I think you've now seen. You sell, you go to a shop, you buy your bag of sugar, and the shop owner tells you, I'll bring the sugar. Then I go to the shop and I buy the bag. Please remember, the bag they're selling me is the one that you bought. Me, the third party, automatically acquire good title. You cannot come and remove it for me. Sell by buyer in possession of the goods. This contemplates a situation where the seller has not been paid. An unpaid seller retains the rights as against the goods. Where a buyer is in possession of goods or documents of title of goods, and he sells the goods to a third party who takes the goods in good faith and for value, the buyer gives a good title, not returning the unpaid seller's rights. Terms of the contract. Terms of the contract. As the general law of contract, the terms of contract under the Sale of Goods Act are divided into conditions and warranties. Conditions and warranties. Now, these are two things that you have to be very careful with. You have to know what a condition is and what a warranty is. And the examiner always asks these questions. The Sale of Goods Act is in itself an implied term of contract of sale that can be rebutted by an express term of contract. These are dealt with in section 2:12:17 of the Act. Now, I know people are going to say, but my dear, you're speaking English we don't understand. Rebutted means you deny the position. You have a general position, then you say, we are not going to agree on this position. That means you're rebutting. So under section 12 stipulates as to time of payment are not deemed to be of the essence. However, courts in England have recognized a new kind of a term, an innominate term. Okay, so we have three things. We have conditions, warranties, and innominate terms. So you have to be very careful. I believe when we're looking at contract, the law of contract, we looked at this. We looked at conditions, we looked at warranties, we also looked at innominate terms. A condition is a major term of a contract, and breach of a condition automatically nullifies or terminates the contract. For example, you go to buy a car and they give you a shell without the engine. They give you a car without an engine. Now, the engine is a condition. It is a major term of a contract. You cannot run a car, you cannot drive a car without an engine. So automatically you reject that car. So that contract will be terminated. But if you go to buy a car and they give you a car with the one side mirror missing, but everything is intact. Now, a side mirror is a warranty. It's not a condition. So the moment you're not going to terminate that contract, you take the contract, but you will pay less for the side mirror. Now, an innominate term is a term which we call an intermediary term. It is a term that is supposed to be fulfilled before the contract is concluded. For example, I come to buy your car, and because I'm a movementist, I tell you that, please, I'm willing to buy this car only if you paint it yellow. Now, the process of painting it yellow makes it an innominate term. So the moment you paint it yellow and I do not buy the car, you sue me for breach of contract. So in KF NV versus Brehma, in which case there was a contract of sale of a contract for the shipment of fruit pellets to be made in good condition. Some of them were, however, not in good condition, but they were still fit for the purpose for which they were intended. The court held that this was not a breach of a condition. The buyers were not entitled to reject the goods. They were only entitled to damages. So at that level, you cannot terminate the contract. The contract runs on, but you're supposed to pay damages. This position is reflected in Section 13 of the Act, which provides that where a stipulation in a contract of sale is a condition, the breach of which may give rise to a right to treat a contract as repudiated, which means terminated, or a warranty, the breach of which may give rise to a claim for damages. Have you seen? But not a right to reject the goods and treat the contract as repudiated. Depends in each case on the construction of the contract, and in a stipulation may be a condition, though called a warranty in the contract. The Act also implies terms into contracts. Yes, terms. There are three terms: an implied condition that the seller has the right to sell the goods, and in the case of an agreement to sell, he will have the right when the property is to pass. That is just an implied term. Two, he has an implied warranty that the buyer shall have and enjoy quiet possession of the goods. For example, you pay rent. The house is for the landlord. But because you paid rent, you enjoy what they call quiet possession till your rent expires. That is what they call quiet possession. The landlord is not supposed to make noise for you. So that is just a warranty. Then 3, the goods shall be free from any encumbrance in favor of a third party unknown to the buyer thereof before or at the time the contract is made. When they say an encumbrance, encumbrances are rights of a third party. Any of you who has land, if you have a land title, there's always what we call the encumbrance page. Look at the encumbrance page. The moment there is a caveat on that land, please, that is an encumbrance. So they're telling you that the seller has an implied condition to the goods that, please, is selling the goods free from any encumbrance. That nobody has an attachment to those goods. It is only him who has the true title to the goods. So they're giving you that case of Roland versus DeVille, where Roland bought a car from DeVille and used it for 4 months. The car had been stolen and Roland had to surrender it to the true owner. The court held that he was entitled to recover the price he had paid for it, notwithstanding the fact that he had used it for 4 months. So, if you buy a shirt from somebody and you realize that the owner of the shirt finds the shirt with you and removes the shirt from you because you have to hand it over, or you bought a phone but it's a stolen phone, and the owner realizes that this is his phone and brings all the evidence to show that it is his phone, the truth is you're supposed to hand over the phone. But you'll come back to the person who sold you the phone to refund your money. That is what the law says. Similarly, where the goods sold can only be delivered by infringing on the trademark, the seller has broken the condition that he has a right to sell the goods. So section 15, where there is a sale by description, there is an implied condition that the goods will correspond with the description. And if it is a sale by sample and description, the goods must correspond to both the sample and description. Section 17 of the Sale of Goods Act of the sale of goods by sample. Okay. You still go, I told you the sale of goods is still, it still stems out of the sale of contract. So if it is a warranty, if it is a sample, there is an implied condition that the majority of the goods must correspond with the sample. But if it is by description, all the goods must correspond with the description. But if it is both sample and description, then all the goods must correspond with both the sample and description. This is still strictly under the sale of contract, under the law of contract. So do not get confused. So Nicole versus Goods, where the plaintiff sold some oil described as foreign refined rape oil. warranted only equal to sample. He sold oil of quality equal to the sample, but it was not foreign refined rape oil. The court held that the goods failed to correspond to the description, and the courts could reject it. Section 16, there is no implied condition or warranty as to the quantity or fitness of the goods except where the buyer expressly or impliedly makes the particular purpose for which he requires the goods known to the seller, such as to show that the buyer relies on the seller's skill or judgment. And the goods are those the seller ordinarily deals with. There is an implied condition that the goods are reasonably fit for the buyer's purpose. There is no this does not apply to goods sold under patent or trademark or trade name. So basically, if your business has always been selling phones and accessories, and when I come to your shop, you convince me and tell me that this phone does this, it has these features and all this, please. The law is saying that whatever you said becomes a condition. And I will believe with what you're saying, because I've come to buy a phone, you're telling me this, so I'm going to believe that whatever you're telling me is fit for the purpose. I remember when we were still at university, very stupid things. At times we would be seated, and when a girl passes, you'll hear guys asking, is she fit for the purpose? And is she of mercantile quality? Can you spend the money on her? And she fit for the purpose? So that is what we used to say. But these were all statements made out of the Sale of Goods Act. At times the guys would say, does she conform to the Sale of Goods Act? Is she fit for the purpose? That is what they are meaning. So lawyers are very funny human beings. At times you might sit with them, but you will not understand that they are backbiting you. Where goods are bought from a seller who deals in goods of that description, there is an implied condition that the goods are of mercantile quality, except if the buyer has examined the goods and there is a defect that the examination ought to have revealed. Goods of mercantile quality was explained in Rogers versus Parish Limited to be as fit for the purpose or purposes for which goods of that kind are commonly bought as it is reasonable to expect. So when they say of mercantile quality, for example, you are the person who has you are one person who has been in the business of sale of G-nuts for the last 7 years. I can't buy a bag of G-nuts from you. Automatically, it is implied that the G-nuts I'm seeing are fit for the purpose and are of mercantile quality. If you tell me that a bag is worth 200,000, I do not need to check it. because I believe it is of mercantile quality. But the moment I take them and I realize that the nuts are rotten, I'm going to sue you for breach of contract. So an implied condition or warranty as to quality or fitness for a particular purpose may be annexed by the usage of trade. An express warranty or condition does not negative a warranty or condition implied by this act unless inconsistent with Section 17. Do not bother with most of these things. We are just trying to explain, to make you know. In the case of sale by sample, there are 3 implied conditions. That is a sale by sample. The bulk shall correspond with the sample in quality. That the buyer shall have a reasonable opportunity of comparing the bulk with the sample. That the goods shall be free from any defect, rendering them unmerchantilable, which would not be apparent on reasonable examination. So that is a sale by sample. So in Grant versus Australian Knitting Mills Limited, where Grant bought some men's underwear based on a sample shown on him by the seller, the underwear turned out to be unfit as it contained an excessive quantity of sulfate, leading him to suffer some skin disorder. Now, I want you to be very, very careful. The examiner might always ask some of these questions: the rights and duties of the parties of a contract of sale. So we'll ask the rights and duties of a seller or the rights and duties of a buyer. And this is what we are now handling. The essential rights and duties of the buyer and seller in a contract of sale are set out in Section 28 of the Act in the following terms. It is the duty of the seller to deliver the goods and of the buyer to accept and pay for them in accordance with the terms of the contract of sale. So just know that is the ordinary position. The ordinary position is you're supposed to deliver the goods if you're the buyer, and the seller is supposed to accept the goods. That is it. So under Section 29, the delivery of the goods and payment of the price are concurrent conditions unless otherwise agreed. In other words, the general rule is cash on delivery. So we are now looking at the seller's duties. Seller's duties. The seller is under a duty to deliver the goods. Delivery of the goods is defined in Section 2 as voluntary transfer of possession. Delivery may take any of the following forms. There is physical delivery. Under Section 30 of the Act, the place of delivery is the seller's place of business, or failing that, his residence, provided that if the goods are at some other place, and this is known to the both parties, then the place where the goods are is the place of delivery. Section 30, clause 2, contemplates delivery to the buyer, and where no reasonable time is fixed for doing so, then the seller must send them within a reasonable time. The moment there is no specified period of time, it has to be reasonable time. Section 33 contemplates a situation where a third party holds the goods. In this case, no delivery is effected unless and until the third party acknowledges that he holds the goods on his behalf, but he does not affect the transfer of the documents of the title to the goods. Then section 30 clause 4 provides that the goods must be delivered at a reasonable hour, whereas 30 clause 5 provides that the cost of putting the goods into a deliverable state are to be borne by the seller in the absence of the agreement to the contrary. So there is the delivery to a carrier, delivery of documents to title, and transfer to the means of obtaining delivery. So we look at the rules, the legal rules as to delivery. The seller must deliver the right quantity. If he delivers more or less, the buyer is entitled to reject the goods. If the buyer accepts such goods, being more or less as the case may be, he must pay for the whole lot at the contract rate. Unless otherwise agreed, the buyer is not bound to accept the delivery by installments. In the case of agreed installment delivery, each to be paid for separately, where one or more deliveries is defective, or where the buyer fails to take delivery of one or more of the installments, whether there has been a breach of contract giving rise to repudiation, or a breach of warranty giving rise to an action for damages, is a matter of fact. So where the seller is to deliver the goods to a carrier, such delivery is prima facie deemed to be a delivery of goods to the buyer. The law implies an agency. That means the carrier is an agent. The seller must enter into a proper contract of carriage for the goods. Where the seller fails to do so, the goods are lost in transit. The buyer may refuse to treat the delivery as a delivery to himself, or he may elect to hold the seller responsible in damages. So section 33 contemplates a case of sea transit. The seller must notify the buyer of such transit to enable the buyer to take out insurance. If he fails to do so, the risk that is attached to the goods during transit is borne by the seller. Under section 34, the risk of deterioration during transit of the goods when they have been delivered to a place other than where they are sold attaches to the buyer. Section 35 retains the buyer's right to inspect the goods as to whether they are in conformity with the contract. Duties of the seller, duties of the buyer. The buyer has two duties fixed by law: to accept the goods and to pay the price for the goods. Only that. So let's look at the legal rules as to acceptance. Under section 37, the buyer is not bound to return the goods which he does not accept. He only has to inform the seller that he has not accepted the goods. So he has no duty to bring them back. He just tells you, I don't want them. Under section 38, where the buyer fails to accept delivery of the goods, he is liable for any loss occasioned by his failure to take delivery, and also for any reasonable charge for the care and custody of the goods. Rights of an unpaid seller. Rights of an unpaid seller. A seller to whom the whole price has not been paid or tendered, where a bill of exchange or other negotiable instrument has been received as conditional payment, and the condition on which it was received has not been fulfilled by reason of dishonor or otherwise. Section 39(2) includes the seller's agents as a seller within the meaning of the Act. All these things just waste our time. Section 40 sets out the unpaid seller's rights. It provides inter alia that, notwithstanding that the property in the goods may have passed to the buyer, the unpaid seller of the goods, such as has an implication of law, a lien on the goods or right to retain them for the price while he is in possession of them. Now, when they say a lien is a possessory right. You only possess the goods not because they are yours, they are for somebody else, but until that person comes and pays the full price, that is when you give him the goods. Then in case of insolvency of the buyer, a right of stopping the goods in transit after he has parted with possession of them. So if the buyer has already sent the goods to you and realizes you've become bankrupt and the goods are still in the way, he has a right to stop the goods in the way. That is what they call trans 2, stopping the goods in trans 2. Then a right to resell as limited by the Sale of Goods Act. So he has a right to resell the goods. So let's look at a right to a lien. A right to a lien is exercisable in the following three circumstances: where the goods have been sold on credit and such term of credit has expired. Okay? Where the goods have been sold without any terms as to credit, and where the buyer becomes insolvent. So the seller will still hold onto the goods because that is a lien. If the three take place, you will still hold onto the goods. The right cannot be exercised where the goods have been handed to a carrier for delivery without reserving the right to dispose of the goods. So the moment you don't reserve the right to dispose the goods, the carrier has the right to dispose them. So you will not have a right to a lien. It will also be lost where the buyer has obtained delivery of the goods lawfully. The moment you deliver the goods to me and I accept the goods, so please, there's no business. Where the seller has waived his right of a lien, yes, he waives his right of a lien and says, kanchikwe, bonafuna sente, oziyazindetera. So he has waived his right. The right of stoppage in trans 2. Right of stoppage in trans 2. Stoppage in trans 2 is covered in section 44 to 46. The right is exercised only where the buyer has become insolvent and where the goods are still in transit. Transit ends when the buyer takes delivery of the goods. The right is exercised by the seller, either taking over the goods or giving notice to the carrier or payee that he wishes to exercise the right. The seller must bear the costs of return of the goods, but automatically you're insolvent. where are you going to get the money to pay for the price or the cost of returning the goods? Becomes so funny. The right cannot be exercised where the document or title has been sent to the buyer and the buyer has endorsed it to a third party who takes it in good faith for value. Yes. So at that level, the principle of neighbor that is lost. The principle of neighbor that is lost. The right of resale. Under section 48, the seller may resell the goods if the buyer does not pay for the goods or tender their price within the agreed or a reasonable time. The right of resale is allowed in the following cases: where the goods are of a perishable nature, where the unpaid seller gives notice to the buyer of his intention to resell the goods and the buyer does not within a reasonable time to pay or tender the price, and where the seller expressly reserves the right of resale. The resale reverts the title in the seller for resale to the subsequent buyer. That is section 48. The above rights are known as real rights. That is, rights that are attached to the goods and are enforceable without recourse to court. So you can enforce those rights without going to court. The other category of rights the seller has is personal rights, which are as against the buyer and are only enforceable through the courts. Under section 49, the seller has the right of action for the price of the goods where the property has passed to the buyer and he refused to pay for them. So there he can sue you, asking for the price of the goods. So the buyer has agreed to pay for the goods on a certain day and fails to do so, pay. So the seller will still sue him. So under section 50 of the seller has the right to maintain an action for damages where the property has not passed and the buyer has refused or wrongfully neglected to take delivery of the goods. The damages payable are based on the estimated loss caused by the buyer's breach of contract. We are now looking at the remedies. So there will be damages for non-delivery. So section 51 provides that where the seller fails to deliver the goods to the buyer may maintain an action for damages for non-delivery. Those are the buyer's remedies. Section 51 deals with the measure of damages. This is the estimated loss directly and naturally resulting in the cost of invoice from the seller's non-delivery. This one does not make sense. Let's look at an action for specific performance under section 52. Such an action can only be maintained where the goods were ascertained and as a rule of equitable remedies is available at the court's discretion. These are, however, rare and will only be granted where the buyer shows that the damages will not be an adequate remedy, e.g. where the subject matter was a sale of a painting of a famous artist. Yes, your contract with Birmingham Palace, and you tell them to sell you the ring that Lord El Fayed gave to the late Princess Diana. and somehow they fail, they refuse to give you, yet you paid the price. Remember, this is something peculiar. You will sue for specific performance. Because even if they gave you the money, the damages, it will not change anything. You have something specific that you want it for. That is what they call specific performance. Then we have damages for breach of warranty. While the seller breaches a warranty, the buyer is entitled to treat the contract as repudiated and reject the goods. He may, however, set up against the seller a diminution of the price or an action for damages. Then recovery of the price. And finally, the rejection of the goods. So that is sale of goods. We are now going to look at negotiable instruments, negotiable instruments, torts, and what? Okay, let me first handle negotiable instruments, torts, and cooperatives. Let me first get the notes on negotiable instruments. So I'll give you all these notes. You'll check which ones are simpler. The other ones have sections. These ones do not have sections. So we're going to look at these ones are simpler. So but I'm going to share all of them. So she'll see which ones to, you'll make a choice yourself, but they talk about the same. So we're looking at negotiable instruments. I believe we have people who work in financial institutions. This should be their area. Negotiable instruments. Negotiable instruments is governed by the Bills of Exchange Act. Bills of Exchange Act. The Act defines a bill of exchange as an order in writing addressed by one person to another, signed by the person giving it, please, I'll remind her genuinely, this time it is me going to be on her case. I'm going to send her everything for her. But I'm going to tell her that, please, these guys have not received their notes. The Act defines a bill of exchange as an order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money, or to the order or a specified person on the bearer. Now, this is the definition under the Bill of Exchange. But I'll go slow. We shall use the position of a promissory note. A promissory note is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay on demand or a fixed or determinable future a certain sum of money to a specified person. For example, as you're leaving home, your siblings tell you that we do not have sugar, this and that. You tell them, you go to such as, you write something down on a paper. Say, please, Joseph, give them the following items and this amount of money. I'll pay back this money in the evening when I come back, and you sign. So the person takes this document. Now, that document is what we call a promissory note. Then we have a treasury bill. I believe you've always seen treasury bills and bonds. Yes, like an IOU, that is true. That is very, very true. An IOU is a promissory note. Then we have a treasury bill. A treasury bill is issued by Bank of Uganda on behalf of government, like a promissory note. And when it matures, the holder can receive the amount. The holder can receive the amount on the treasury, and it is even transferable. Now, at times people get confused. They will see a treasury bill being issued by a commercial bank. Please, it is the Bank of Uganda that has issued that treasury bill. Only that it is the commercial bank releasing it. They will tell you that there are always treasury bills and bonds. Treasury bills and bonds. They will say, whoever did the economics, genuinely should be in position to help us on this. It is one of the ways of curbing inflation. It's one of the ways of curbing inflation. You will say, they will say, whoever has 20 billion shillings, do bring the 20 billion shillings to us, and we give you this bill or bond. But you're going to have this bond for the next 2 years. But the moment it matures, we shall give you an interest of 20%. So that is what they call a treasury bill or bond. Then we have a dividend warranty. Dividend warranty. Remember dividends. You're going to know that dividends are issued when we tackle company law. Oh, we tackled company law, yes. Dividends are issued by companies. The profits that are given to members of the company, the shareholders. So that is what they call dividends. So a dividend warranty, this is an order or warranty issued by the company and drawn up on its bankers in favor of a member of a company for payment of the interest or dividend due to him upon his holding of a share or stock in the company. So those are the profits you get. Then we have a check. A check is an unconditional order in writing drawn on the banker, payable on demand. Payable on demand. Now, we have two types of checks. We have what we call a cross check, and we have an open check. An open check is the one we are talking about. It is written, it is unconditional. You take it to the counter and they give you money across the counter right away. But a cross check has two lines in between. It shows that it has been crossed. Meaning, this check matures after a specified period of time. That is one thing you must know. It matures after a specified period of time. The examiner may ask you a question that what are the circumstances that might lead to a check not to be honored? What are the circumstances that may lead to a check not to be honored? One of the grounds is that the check has expired, because checks also expire. They have a lifespan of 6 months. The moment the 6 months lapse and you've not banked the check, it automatically expires. So at that level, the check would have expired and you will not get the money. 2, the person, the bearer, the insurer, the issuer of the check, the person who has issued the check does not have enough money on his account. Automatically the check will bounce. 3, the erasures on the check. The erasures on the check. Okay. We have what they call post-dated checks. I can write a check now and I say, please, you will effect this, the payment of this check will be on 2nd June 2026. That check is okay. That one has not lapsed, it has not expired. It only expires if the date is for today and it has taken 6 months. Six months without you banking it. That is when it expires. But if it is post-dated, please, it only begins running after the date that the check is supposed to run. So, parties of the bill of exchange. We have the drawer. The drawer is the person who has written the check. Then we have the drawee or the bank, meaning the person going to pay the money. Then we have the payee or the holder or the beneficiary, means that is the person supposed to receive the money. So where a bill is incomplete or has erasures, there is it being incomplete, meaning you've written the check, but you've not put the date or the amount. That means the check is incomplete. Or it has erasures. You've written each and everything, but you've wrapped and you're writing other things. So those are erasures. It will not be honored. Then it will not be honored. Then we have a holder in due course. Is a person who has taken a bill, complete and regular on the face of the it. And if he brings that bill, please, it will be honored. And if he brings the bill, will be honored. Now, this is what we're discussing on the principle of nemo dat. The principle of nemo dat. That he who has no title cannot pass on good title. Cannot pass on good title. So please, that's still telling you the same principle in negotiable instruments. That if somebody has stolen a check and he has passed the check to another person, God, let me tell her that we are going to send these notes. Just give me a few minutes. Yeah. Yes. Yes, I'm sharing. What is happening with the sharing? Okay. Where the bill is incomplete or has erasures, then it will not be honored. A holder in due course is a person who has taken a bill, complete and regular on the face of it, and if he brings the bill, it will be honored. Duties of the customer to the bank. The customer has a duty of reasonable care in drawing checks. So do not make mistakes. Do not be careless so that these people steal your check leaves and begin drawing the checks, misrepresenting that it is you. Then a duty to inform the bank of any forgeries. But unfortunately, it is our banks that inform us that has is it you who has written this check? That is how bad it is. Then the duty of the bankers to the customer. Duty to honor the customer's mandate. Then a duty of skill and care, and a duty of secrecy and confidentiality. So we are supposed to begin off with the law of torts. To be safe, your admin is telling me there are some notes that you guys don't have, and I concede. Now let me send the notes to her. Don't say that I've just refused. I genuinely want to give the notes because today I thought we would finish TOTS and the cooperatives, but we still have 17 minutes. Let me just use those minutes to send the notes to her. Just bear with me. Let me wish you a good night, or if you have any questions, you can keep asking. Because I know we're going to begin off with TOTS and negotiable instrument and cooperatives, then we finish that. We go to land. If we have time, we finish land. We shall look at, if we finish the 3 topics, TOTS, cooperatives, and land. I believe that will be our next. And the last will be dispute resolution, PPDA, URA, all that. Courts. Then we embark on genuine. Whoever has missed the notes, you let me know. What I'm going to do is let me send Maria the notes again. If you have any questions, please, you can ask. But just know we're beginning off with TOTS next time. Okay, let me send the notes right away. Let me wish you a good night. Whoever is going in for, I don't know, is it CC Winans? Please. I know there are very many things happening tonight. But CC Winans, I believe she is about to stop. Because I knew she's stopping at 10. So guys, good night. Let me send the notes right away.